Liability of auditor.
Liability under statute. Company Act 1965. Companies Act 1965 govern the auditors in Malaysia, of which auditor has specific duties and responsibilities under Section 9. Qualification as auditors. Section 172, Appointment and Remuneration of Auditors, and Section 174, Power and Duties of Auditor. For example, the auditors can become the whistleblower when reporting company's financial statement, such as to report a non-compliance with any provision of the Companies Act 1965. Securities Commission Act 1993. Securities Commission, established by Securities Commission Act 1993 as approving and registering body for prospectus issued in connection with public securities offering. The non-compliance of the Act by the company or borrower in the case issuing debenture can be reported by the auditor. Banking and Financial Institution Act 1989. Banking and Financial Institution Act 1989, Licensing and Regulation of Banking Institution. A report to the Central Bank, Bank Negara, should be made immediately if violation of BAFIA by the bankers arises. Securities Industry Act 1983. Securities Industries Act 1983 governs the trading of securities on the stock exchange. When there is a breach of securities law, the auditors need to make a report to the authorities such as Securities Commission. Lastly, Anti-Money Laundering Act 2001. Anti-Money Laundering Act 2001, dealing with law and penalties of money laundering and measure for preventing such activities. It imposes a legal duty on a reporting institution, including auditor, to report unlawful transaction to the Financial Intelligence Unit of Bank Negara. Liability to shareholders and auditees. First, due care. It can be applied to the performance of an auditor's duties by referring to cases decided in UK and Australian court. The interpretation of due care and reasonable skills and diligence has changed over time. The relevant of professional standards are auditing standards in determining the adequate performance of audit work and accounting standards in determining the basis for expressing an opinion on fairness of presentation. Second, negligence refers to a careless or unintentional in nature and a breach of any contractual duty or duty of care in wrongful act to another person. The client may sue the auditor that has negligence for breach of an implicit term of the contract to exercise reasonable care and skill, and also wrongful act to obtain damages sufficient to restore the client to its original position. Third, privity of contract. It can be defined as the contractual relationship that exists between two or more contracting parties. In an auditing relationship, an audit is assumed to be performed in accordance with professional standards unless the contract contains specific wording to the contrary. The term members is used collectively and does not indicate responsibility to individual shareholders or others entitled to receive copies of the accounts. Fourth, causal relationship exists between the breach of duty by the defendant and the loss or harm suffered by the plaintiff. The relation must have been reasonably foreseeable, and it must be proven that the loss suffered is attributable to the negligent conduct of the auditor in negligent cases. Fifth, contributory negligence. It relating to the failure of the plaintiff to meet certain required standards of care. Regarding to defendant's negligence, it contributes to bringing about the loss in question. This kind of negligence is taken to mean that the court tends to examine all relevant circumstances to judge the likely proportion of liability attributable to respective parties. 6. Damages. The damages happen when the auditors fail in their duty to act with reasonable care and skill, whether under contract or in wrongful act. A plaintiff is entitled to recover any economic loss arising out of such breach of duty. The auditors need to consider what is the purpose of statements that may give rise to reliance reasonably being placed on them, and also to what extent may responsibility for any loss be assigned on the one hand to the auditor's negligence and on the other to another causes and other parties.
Liability under the common law. Auditor has liability to clients and third party under the common law. Liability to client due to breach of contract, negligence and fraud. Firstly is breach of contract. Based on the auditor failing to complete the services agreed to in the contract with the client, an engagement letter should establish the responsibility for both the public accounting firm and the client. Next is negligence. Refer to a wrongful act other than a breach of contract for which civil action may be taken. If an engagement performed without due care, the public accountant may be held liable for actionable torts in negligence. Liability for negligence represent a deviation from a standard of behavior that is consistent with a reasonable person. Lastly is fraud. An auditor can held liable to client for fraud when he or she act with knowledge and intent to deceive. Liability to third party. Third party liability can be defined as a bodily injury and or material damage caused to a third party as a result of action or inaction or negligence, and which injury and or damage must be remedied. Breach of contract and negligence. Breach of contract. Failure to perform a contractual duty that has not been excused. For audit firm, parties to a contract include clients and designated third-party beneficiary. Example, failure of Company Act to deliver a tax return on the agreed open date. Next is negligence. Failure to exercise the degree of professional care and skill appropriate to the circumstances of the case, thereby causing harm to another or to property.